Welcome back. That was Crystal Colley Wright. She is the sister of James Colley. We are in the sentencing phase of the death penalty trial out of Florida. James Colley was found guilty of murder and burglary on many other accounts as well. And the jurors just took a break. The court just took a break. We listened to direct, cross, redirect, but no recross. Obviously, the sister does not want her brother sentenced to death. For her, it's a sad story all around. Many lives and many families torn apart on this case. With me is Francey Hakes. Francey and I discussed this case together on set last week during the actual trying of facts on whether or not he would be found guilty. This is the case where he was in a Florida house. He went after his estranged wife. He gunned his way into the house. He then, rather than killing and hunting the boyfriend that he felt was in his way, he then shot and killed his wife, Amanda Colley, and then her best friend, Lindy Dobbins. Two others escaped. Many victims to these heinous crimes. And now we're in the death penalty phase. Florida's a death penalty state, and in order to get the death penalty, all the jurors must agree unanimously that that is the best decision for James Colley. So right now in the sentencing phase, there's a lot of mitigating factors, aggravating factors, relaxed rules of evidence get to come in, hearsay gets to come in, and the jury gets to listen to things that they otherwise may not have been able to hear in the actual trial. So Francey, you've been following this for a while with me. What do you think? You think he's going to get the death penalty?
You know, Carissa, it's so hard in cases like this. Well, it's hard in every case to get the death penalty. I think it's very difficult for jurors to decide to give the ultimate punishment when there are a lot of people in our society who think that it is far greater punishment to have to sit in prison the rest of your life. But as we've seen from some of these cases out of New York recently, where the New York Parole Board has released killers who murdered cops back in the 70s, life without parole doesn't necessarily mean that. But I think jurors really like to take that way out. I think the prosecution is making its case. I think it's also hard for the jury when you've got defendants' family members humanizing the defendant to the jury.
It's exactly right. Humanizing is the key word that you said right there. When a defendant is no longer a monster on the stand and he's showcased just for the crimes that committed, and this panel of jurors have decided and sort of boxed him in of this is what this person is, this is who he is, and this is what he stands for. And then when you bring in family members, like you said, it humanizes him because you get into the layers of complexity of a human being. And it's very hard to say that one person's all good or all bad.
Well, you're right, and it reminds me of the death penalty case that we were covering a few weeks ago from Ohio, Sean Great, where the defense also in that case brought in the penalty phase his family members to say that he grew up in a household where there was abuse between the parents. And that's exactly what this defendant, Colley's sister, just said.
But that case, because I'm not sure if we discussed that one together, but that case was particularly horrific. I mean, wasn't that the case at the House of Horrors of him getting 3 different victims and going on a killing spree, raping spree, kidnapping spree in all a very short period of time? Is correct? That's the Sean Great case.
That's the one, yes.
So this case is different in that you're dealing with triggering events. You're not dealing with a monster came out in this case. A monster absolutely came out. There's evil here that exists. But you're not dealing with someone that is so evil that they just go prey on innocent victims. Although Amanda Colley was innocent and Lindy Dobbins is innocent, it seems to me that something triggered James Colley in this case, and something caused him to snap. The defense is going to say it's the Ambien and other mitigating factors in his system. I don't know. That's going to be for the jury to decide. But I agree with you. It's so much harder on these cases to get the death penalty because a lot of jurors will have a moral issue with having that blood on their hands at the end of the day.
Well, that's true, Carissa. And you have the different cases here. You've got the difference between a serial killer like Sean Gray and what you might call a spree killer like James Colley. And jurors have said in their death qualification, in the selection of this jury, they all said that theoretically, if they had the choice and if they thought the evidence merited it, they could impose a sentence of death. But it's one thing to say you could and another thing to actually do it.
And that's life, isn't it? It's so much easier to say something than actually do it. And anything in life, being a person of your word and being able to follow through is a rare trait to have. We're going to continue to follow this case and the sentencing and death penalty phase of the Colley case, along with other trials that we're watching here on the network. But before we do, we're going to take a look at other top trending crime stories around the country. Let's take a look.
Here are today's top crime stories trending on lawandcrime.com and across the country. A man in New Hampshire was arrested after he was allegedly caught working out naked at a Planet Fitness. 34-year-old Eric Stagno reportedly entered the gym, stripped naked, and proceeded with the yoga routine. When confronted by officers, Stagno allegedly said he thought it was a judgment-free zone, a nod to the Planet Fitness slogan. Stagno was charged with indecent exposure, lewdness, and disorderly conduct. The father of Josh Powell, the man who killed himself and his two young sons while under investigation for the killing of his wife, died of a heart attack in Washington. 68-year-old Stephen Powell, who himself was convicted for possessing child pornography, died in St. Joseph's Hospital in Tacoma. His son, Josh, killed his two sons and took his own life in February of 2012 as authorities investigated him in the disappearance of his wife, Susan Cox Powell, who went missing in December 2009. Video of officers in Georgia forcefully restraining a young boy during a domestic violence investigation has gone viral, with many questioning the actions of the officers. Officers were responding to a call of alleged domestic violence in Athens, and while making an arrest of a suspect, the emotionally distraught son of the suspect confronts officers.
I'm sorry.
Can you do okay?
Yes.
I understand.
Yes, sir.
You don't run another police officer. Okay? So go.
An internal investigation of the officers' actions is ongoing. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Thanks, Anthony. All right, let's talk about that last story. Francey, we just saw that, and how sad. A little 9-year-old boy being held down by police officers because his daddy is being arrested after a domestic dispute. The little 9-year-old lunged towards police officers to rescue his dad, saying he didn't do anything, he didn't do anything. And then you hear him on the ground saying, I'm sorry, I'm sorry. A little bit more, that's the father on the screen right now that you see. We don't know what he did wrong. We don't even know if it's a legitimate charges. Right now, the officers are being accused of excessive force. But the officers are saying that they just tried to restrain him. As you see, the second one put his hand on his shoulder to calm him, and the little boy is saying, I'm sorry, I'm sorry. And then they let the little boy go to the car where his father was arrested, and they rolled down the window, and they let him take his phone. And the 9-year-old said, I promise to give the phone to someone who can bail you out. I love you, Daddy. I mean, how sad. A 9-year-old has to be restrained, and this went viral on social media as police brutality, excessive force. What went on social media wasn't the whole picture. But what the police officers are saying is the full context, because they had a body cam. What do you make of what we just saw? Is this excessive force? Sad for the kid? A racially motivated case?
It's very distressing, Carissa. It's very distressing anytime you see police interacting in any sort of forceful way with a child, especially one this young. But again, you made a great point. The whole video is not the part that went viral on social media. What went viral was just the child being held down on the ground by two police officers. He's a young black child, two white police officers, and of course it looks bad. But when you explain the whole context that the child actually lunged at police, we don't expect police to have to take being assaulted, even if it's a 9-year-old. And yes, what could the 9-year-old have done? Were they in any danger of their lives? Probably not, but they're both wearing weapons, and they're taught to put suspects, whatever their age, on the ground until any threat is neutralized. And it seems to me that's what they were doing here. Did they do the right thing? You know, I don't know, but in looking at the entire video, it looks like they took the easy, most least restrained way out, put the child on the ground until he calmed down.
Yeah, calmed him down. And you do see the other officer put his hand on his shoulder in a calming way. So, but when you take it out of context, it's easy to misconstrue it. But we need to go to a quick break, and then we're going to continue to analyze the Colley case. So stay with us. Direct examination of Corey Roderick McMath. He is the owner of the house where the party was before the killings happened. And he is walking us through the moments leading up to the killing of what happened in his house, what were the circumstances, what were the surrounding environment, did he notice anything out of the ordinary? This is direct examination. The prosecution is putting on its case. With me, Francey Hakes. Let's discuss and dissect this matter. Do you feel like this testimony is lending any critical insight for the jury to help make this manslaughter case an actual conviction? Because as you know, and as the viewers know who have been following this, this is a case of he said, she said. Who's the aggressor? Why was he sent to the party to be muscle, to resolve some other dispute? And we don't really know if there's a self-defense claim. From what I heard just now, I don't hear any insight gleaming, any testimony that would sway me if I were a juror one way or the other. What about you?
Well, Chris, I think what the prosecution's doing here is they are trying to say that the victim, when he left the party, was not in a rage. He was not out for revenge. He was not angry about anything. So what they're trying to do is to suggest to the jury that there was no way the victim was the aggressor, that it must have been the other man, who testimony earlier suggests that the victim honked at the defendant and that caused the incident. This seems to me,
so, like, does honking make someone an aggressor? Oh, I honked, so therefore I'm telling you to go. You're at a stop sign and you're not moving, so I'm going to honk my horn. So now that makes someone an aggressor?
Well, of course it shouldn't, and it's ridiculous. But you know as well as I do.
We've got to throw to a quick break. We're going to come back to this because it's interesting to dissect who is the aggressor. Stay with us, and we'll be right back. Welcome back. I'm Carissa Kranz. Before the break, Francey, Hakes, and I, my guest, were discussing the Demetrius Elder case, 2014 case out of Florida. This is a case, it's a manslaughter charge. 30 years is what the defendant is facing for stabbing the victim 6 times with a fatal wound to the heart. There are disagreements on whether or not this is self-defense and who the aggressor is. So before the break, I had to cut off Francey, and I want to go back to that conversation that she and I were having. Francey, you know, you said that they were stopped at the stop sign and then the victim honked the car, and I said, well, does that make him the aggressor? And we had to go to a break. So I'd like you to finish that thought of who is the aggressor in this situation.
Thanks, Krista. You know, it looks like this is kind of a classic road rage. And I think we were starting to talk earlier about how road rage certainly doesn't justify murder. And of course it doesn't, or even manslaughter. And of course it doesn't. But we hear about it happening all the time. And I think that's what the state is trying to depict here, is that the victim did something we all do. That is, honk his horn, probably in impatience. Maybe the person in front of him, the defendant, wasn't moving through the stop sign as fast as the victim thought he should. So he honks his horn and was killed for it. That's
but arguably, honking his horn is not really what caused it. The victim took it one step further and actually got out of his car and approached the other car at night, which could startle someone under certain circumstances. I think where we lose the train of him being the aggressor is the girlfriend's testimony said that they sort of shook hands and then he started to retreat and go back to his car when he was then jumped. So if her testimony is true, then the first car, the defendants, are the aggressors. But it's a he said, she said story. So, of course, the defendants have reason to come up with their own narrative of what happened. And, of course, the girlfriend of the victim has her idea of the narrative because she wants to hold someone accountable for her boyfriend being killed for a guy wanting to roll through a stop sign, unless there's some backstory we don't know about. That's another possibility. One more thing I want to bring up and ask you before we go to our next back into the courtroom is this case is charged as a manslaughter case, not a murder. Is that prosecution's strategy to not overcharge the case because they know they have a weak case?
Well, I don't know. I don't know if it's because they think they have a weak case so much as they're charging what is accurate here, and that is what looks like a road rage incident, which is most appropriate for manslaughter. I have to say, though, you don't stab someone 6 times in self-defense. No. So if that's the defense claim, it's going to be a tough row to hoe.
So why not charge it as murder and have manslaughter as a lesser?
Well, I think, Carissa, most likely the prosecution feels that there is some level of participation. I don't mean culpability, but some level of participation in the escalation of this encounter by the victim. And so they felt that manslaughter was the more appropriate charge than murder, which requires premeditation. Although I think, as we talked about last time I was on with you, premeditation can be formed in an instant.
In an instant, right. So why not charge it up and then instruct the jury on the lessers? There must be a reason behind that. I think it's because it is a tough case to prove. You have conflicting stories and no real eyewitnesses that are credible and not biased. Both eyewitnesses are clearly biased. But we're going to continue to monitor this. We're now going to go to another clip. This is Corey Roderick McMath. We were listening to him before, but now this is cross-examination. This is the owner of the house that was hosting the party and his recount of what happened moments up to the altercation and the road rage and the stabbing. Let's take a look. Welcome back. I'm Carissa Kranz. That is testimony of Corey Roderick McMath. We're listening to cross-examination, and as you can see there, he was getting very unsettled. He started questioning the defense attorney on cross as if he was the attorney crossing, asking questions like, what does that have to do with the murder? With me, Francey Hakes. Francey, let's dissect this and discuss this because, you know, they're trying to show motive in this case. They're trying to say that there's a reason the victim was called to the house because of some other isolated incident, possibly isolated, allegedly isolated, we don't know, about another friend's broken jaw. And then you hear the witness on the stand in cross saying, well, what does that have to do with anything? He's totally poking holes into the defense narrative that there was motive to send the muscle man to the house, which made him become a victim later on. And on top of that, we just heard him say that he was drinking and he was high and his memory was foggy. Is this credible testimony?
You know, what's interesting about that, Carissa, is common sense view says it's not credible. However, jurors love this kind of witness because he is honest. He's real. This is what a real person would do if his friend was murdered and he was indignant about it and wanted someone to pay. So while the prosecutor's probably cringing a little bit at his arguing with the defense and even questioning the defense, the jury probably loves it and probably really finds this guy credible. I do.
I do too. I actually think that because he was so confused and so real, like you said, I think real is a good term. It shows to the jury a human element of transparency and honesty, which is why everything that's in the trial court is so important, and it's so much harder to appeal cases because the jurors are the ones that see that, they witness that. There's only so much that a court record or a transcript can, or even a court reporter can actually capture in a trial. So words are one thing typed on paper, but when you see that interaction in the courtroom and you see the tone and you see the eyes and you see the forehead cringe of confusion, you see that it really isn't related. It probably was a road rage case, because he said he wasn't upset about his friend getting his jaw broken, and he couldn't understand how it could be related. So interesting stuff to consider. We're going to go back into cross-examination. There's additional testimony from Corey Roderick McMath. Again, this is the friend of the victim, but he was having a party at the house with about 15 to 16 people. So his testimony is critical because he was an eyewitness to the moments leading up to the murder. However, so far, it doesn't seem like anything out of the ordinary was happening at the house except for a normal party of drinking and then drugs, specifically smoking some weed, which has fogged the recollection, admittedly, of this witness. But let's take a look. That's Wendy Gambelis. She's the girlfriend of Mohammed Knight, the victim that was fatally stabbed and killed that night after 6 fatal wounds and the blow to the heart. Really just sad facts. This is direct examination. This is a prosecution witness, so the prosecution is breaking down for the jurors and for us as the viewers her eyewitness testimony of what happened, what she saw blow by blow before the final blow. With me, Francey Hakes. Let's discuss and dissect this. Right now, this is cross-examination, so she seems pretty credible in her testimony of what she saw. Nonetheless, not even, you know, they were the car behind the car in front of them, so she had the best view. She really had front row seats, right? She was a passenger in the car, saw her boyfriend, Mohammed Knight, the victim, get out of the car, approach the car in front. So she really saw the whole thing go down. What do you make of her testimony so far?
Well, Carissa, she was certainly in the best position to see exactly what happened. And so far, I find her to be very credible. She doesn't seem to be someone who is, I would consider to be super sophisticated or slick. She just seems like she is relating what she saw the way that she saw it. And it's smart for the prosecution to have first stepped up and said, okay, what happened? And then said, oh, wait, let's go back and let's go through this slowly. And that's what they're doing now. And I think it's really smart. She appears credible to me.
She appears credible. And I also like the way she said that he extended his arm as if to shake the hand. That's very different than an aggressive lunge. Right now, there's a discrepancy on even who had the knife. According to the girlfriend, the defendant had the knife. According to the defendant, Mohammed Knight, the victim, had the knife. This is he said, she said, but no doubt she had the best seat in the house to have the best eyewitness testimony. So let's see what happens on cross-examination after we go to this quick break. Stay with us. Welcome back. I'm Carissa Kranz. We are closely watching the Demetrius Elder case. This is a 2014 manslaughter case out of Florida. The jury is coming back from break, and during break, there they are. You see the room. That's our live feed into the courtroom. During break, we saw the defendant being seated and coming back into the room. However, I shouldn't say being seated, because if you were watching the live feed and noticing, he was actually being wheeled in a wheelchair. I then asked the producers, why is he in a wheelchair? This is an aggressor that stabbed the victim, Mohammed Knight, 6 times, killing him with a fatal stab wound to his heart in addition to throwing punches. How is he in a wheelchair? Apparently there's some autoimmune disease that has caused him to be in a wheelchair. Francey Hakes, I want to talk about this because to me, this is a ruse for the jury. This is theatrics. This is trial at its best, because a trial is like going to the theater. You want to garner as much sympathy as possible, and the jurors are watching the defendant be weak and meeble, which is clearly going to garner sympathy for these charges on him being this strong muscle man aggressor, right?
You're so right, Carissa. I mean, and the phrase is perfect, trial theatrics. And that's what it is for defendants. You see these huge, towering, rage maniac killers come into court in a nice little sweater. Or you see them being wheeled in like the Golden State Killer, the alleged Golden State Killer, in a wheelchair when we know that just a couple of days before he's racing around on his motorcycle. So this isn't surprising at all that they're trying to engender sympathy.
I believe, and I think that's exactly what it is. And they probably, I bet there were emotions ahead of time on whether or not this was a fair theatrical sample to do in court, and they probably have medical records proving an autoimmune disorder, which would allow him to be in a wheelchair. But this is, I believe, theatrics causing him to be in a wheelchair, not really the disease. But something
it certainly
to
looks
discuss
that
and
way.
take
It's
note of.
definitely possible.
listen, everything's possible, but is it reasonable, right? That's the standard we're in. Let's go back into courtroom. We have a live feed. It looks like there's a new witness that's taking the stand, and Francey and I will be back to discuss. For those of you just joining us, this is Detective Hector Bertrand. He is the responding officer to the scene. This is the Demetrius Elder case out of Florida, 2014 case. A Florida man, Demetrius Elder, is charged with manslaughter for fatally stabbing a man during an encounter at a stop sign. Right now, you see him opening evidence and authenticating the evidence, which is just procedural in order to get evidence admissible for a jury. We're going to go back to court to see what this evidence is right now. Welcome back. I'm Carissa Kranz. That is Detective Hector Bertrand, the responding officer. He's authenticating evidence. And right now, you just saw him authenticating pictures that were taken of the scene. In the courtroom, we are following it closely live with a feed. And right now, there's a little bit of silence because the jury is being handed the pictures to review them for their own process of deliberations later. This is being admitted into evidence so they can look at these pictures at any time. With me, Francey Hakes, thank you for joining me. Let's talk about this witness and why his testimony is or isn't critical. I know on break you and I were not sure where the state was going with this. Since we spoke during the break, do you have any more insight on where the state is going with this?
Yeah, Carissa, this lead detective obviously is getting into a lot of evidence here, and he talked about body warrants that they took out for both defendants. And those body warrants included photographs of each defendant. I suspect, I could be wrong, but I suspect, as you said earlier, that they're going to show that there were no or minimal injuries on either defendant in order to negate the defense's claim that this was some kind of mutual combat or mutual fight. So the jury is looking now at photos of the co-defendant Batista, and I assume they will then also see photos of this co-defendant, the defendant on trial, in short order. Okay,
and let's just describe for the viewers what the heck a body warrant is, right? Like, can you explain what that is for people who don't understand? It's probably what the pictures are that they're looking at now, which we haven't seen the pictures. It's not like they were held up to the screen, but like you said, to show the wounds, the lack of wounds or whatever. But what exactly is a body warrant?
Well, Detective Bertrand testified that for them, a body warrant is everything: photographs, palm prints, fingerprints, so they could get every piece of identifying or unique information about each defendant so that they could later prove whatever the theory of the case is.
So a body warrant is basically a warrant, just like a warrant to a house. You have probable cause to go into that house to seize whatever items that you may find. You have grounds to go in. A body warrant is you have probable cause to seize that person's persona and identity, to investigate it, to find evidence, to lend a narrative to a case which may or may not tip the jury one way or another, right?
That's right. And these warrants are very common. They could be warrants for blood evidence, warrants for saliva, warrants for DNA of the skin. They could be warrants for photographs. All of this is within bounds for these kind of warrants that the state feels like they need in order to help prove their case.
So have you ever seen a body warrant get thrown out on a technicality? Like in court all the time we see search and seizures that are thrown out because there wasn't probable cause or proper probable cause. Have you ever seen a body warrant, evidence collected, DNA, swabs? I mean, talk about losing your privacy. You're not losing property in a house. You've lost your identity to the system.
Well, that's right. I don't think, Carissa, that they get thrown out all that often because the probable cause, especially in a case like this, for example, is pretty easy to prove. You have an eyewitness who says these two defendants assaulted and stabbed her boyfriend. That's enough probable cause all on its own to give them all they need in order to get warrants to take photographs and fingerprints and saliva and DNA if necessary.
So I wonder if these body warrants are consistent with him being in a wheelchair right now. As you can see, we have the defendant on the screen, and if you look closely, there are handles behind. Up now, there's a head covering it because he's whispering. But up there you go. There's the handles, which shows he's in a wheelchair. And as we see him getting wheeled in and out of court, there's some concerns and questions in my mind whether or not he was truly suffering from an autoimmune disease causing him to be in a wheelchair, or if this is garnishing support or sympathy from a jury to make him look weak and feeble. Interesting points.
Carissa, that's a great point, and that's something the defense always tries to do, and it makes it hard for the state. The victim is not there. The victim is not sitting in court. This humanizes a defendant, first to just sit in court, to talk to his lawyers, and to be in a wheelchair may very well engender sympathy that the state
That's exactly
doesn't
right.
want to
We're going to
have.
go to a quick break, and we're going to come back and continue to discuss this case. Welcome back. That's Detective Hector Bertrand on the stand. He's the responding officer, and he is going over his findings at the scene. First, it was admitting some evidence, and then it was processing the evidence. It was showing the jurors some of the pictures. It was commenting on the wounds because of the body warrants. And now he is discussing the girlfriend and his findings when he interviewed her, and how it conflicted, because it's cross-examination right now, how it conflicted with the other detectives' questions of her, which is the defense's way of disputing her credibility. With me, Francey Hakes. Francey, let's discuss this witness. It's a kind of a procedural witness, but nothing inflammatory. Do you feel like he is adding insight to this trial, or this is more about laying out the evidence for the jurors to just have it all admitted so the record is clean?
Well, there's two purposes for this witness at this moment. First, when the prosecution put him up, it's to provide an overview of the case and to admit all the evidence that they think is relevant and to prove or disprove certain elements. But for the defense at this moment, it's all about trying to make the jury question the state's investigation. Two investigators disagree, or a witness gave one statement to one investigator and a slightly different statement to another. Is it the investigators who are wrong, or is it the witness who's telling a new story, which can allow them to imply that the witness is lying and challenge their credibility?
Right, and that's always a question, right? Like, did the detectives ask the questions wrong? Is that why we don't have the full story from the first interviewer? And then the second person asked different questions, so then they got more information or additional information. Why are certain things omitted? But luckily in this case, we're going to actually get to hear from the girlfriend herself, so she can reconcile those inconsistencies on the stand, doing direct, cross, and redirect and recross examination, right?
She can, hopefully. That's the difficult thing, is that a case like this, for reasons I'm not sure of, the incident actually occurred 4 years ago. People's memories fade.
Right, so her memory, she may have to refresh her recollection. It may not be credible. We'll see how she handles herself on the stand. We need to go to a quick break, but we'll continue to monitor this and go back into the courtroom when we return. Welcome back. I'm Carissa Kranz. We are following closely the Demetrius Elder trial out of Florida, 2014 manslaughter case. Right now on the stand, we're listening to Detective Hector Bertrand. He is the responding officer. Before the break, Francey and I were discussing the testimony of him interviewing the girlfriend and the inconsistent statements. I want to pick up where we left off before we go back into court and ask you, Francey, is there a reason, or is there some kind of neglect, that he didn't review the statements that she gave to the other officers and the other detectives before his own statement, in order for him to maybe close the loopholes and close the gaps and be a better interviewer? Is it his fault that there are inconsistencies rather than her fault?
You know, Carissa, that's such a great point. You can argue this really two ways. If he had reviewed her statement before doing his own interview of her, the defense would then accuse him of listening only to whatever was in the statement when he reviewed it. But since he claims he didn't review her statement before interviewing her, now the defense is implying that he is somehow committing some sort of process violation, is that he was negligent in his interview. I could believe he should have reviewed the statement.
Okay. All right, we're going to go back into court, but I do agree that what you said, it's a good argument to be made for a possibility that he was negligent in not doing his due diligence before taking her statement, because he could have closed the loopholes here, could have closed the follow-up. Let's go back into the courtroom where we have a live feed, see what he has to say. This is cross-examination of Detective Hector Bertrand, the responding officer to the scene in the Demetrius Elder manslaughter case.
Clean it.
This is Detective Hector Bertrand, the responding officer. We've been listening to testimony for a while. We were on direct, and now we're on cross-examination. And the only thing that's really interesting to talk about, Francey, this is Francey Hakes joining me, are the mannerisms of the witness. You were mentioning a couple things in my ear, and I wanted to share that with our viewers. So what do you make of the way he's answering the questions while he's on cross-examination?
Well, Carissa, this witness has obviously testified a lot in trials. He's being very careful. And if you notice, every time the defense attorney says, you talked to so-and-so on this date, he doesn't just take her word that he talked to so-and-so on that date. And he also makes sure it wasn't just him that talked to so-and-so. He looks at his notes. He wants to make sure the defense attorney is not going to be able to misquote him.
Right, and that's important because if you misquote one thing, then it is so easy to be impeached because then you get to cast doubt on all the testimony, and then you get to say to the jurors, well, what else doesn't he remember? What else did he mess up? Or what else was he sloppy on? So it's very important to always remain accurate. And you're right, he is a seasoned witness, and he knows that the defense is not on his team as he is being cross-examined by the defense attorney right now with our live feed in the courtroom. This is the Demetrius Elder case out of Florida, 2014 case, manslaughter charges, a co-defendant case. Right now, one defendant is standing trial. We're going to continue to monitor this case closely in the courtroom live because that's what we do, but right after this break. Stick with us. Welcome back. I'm Carissa Kranz. We are following closely the Demetrius Elder case out of Florida, the 2014 manslaughter case where the defendant is standing trial for allegedly stabbing 6 times with a fatal stab wound to the heart the victim, Mohammed Knight. There is conflicting statements on whether or not this is self-defense. Right now, we have on the stand Detective Hector Bertrand. He is the responding officer. And while we were on break, there he is on the screen. While we were on break, we heard him say that the body warrant of Armando, the defendant, was 2 weeks after the incident happened. So earlier, Francey, we were discussing about body warrants and how everyone had a body warrant, and that was the right to seize the body and the swabs and the DNA to actually review the evidence and come up with whether or not there may or may not have been a fight and who the aggressor was or wasn't. Does it matter that there was a 2-week delay to seize the body to do the search of a warrant of the body?
Well, of course it does, Chris. It's going to allow the defense to argue that any wounds or injuries that they had from the aggressive victim have now healed.
Right.
Now, any serious wounds wouldn't have, but superficial wounds might have.
Right. So that's what's so interesting and strategic, right? So on the direct examination, we had the state basically lay the foundation that there were no wounds, that the victim was clearly the victim, and if the victim was the aggressor, then the defendant would have marks and bruises that really showed that he was being attacked. Now, on cross-examination, we have the defense attorney bringing out into evidence that the body was not evaluated until 2 weeks later, which everyone knows in 2 weeks, a bruise and a cut can easily heal. So that was an interesting point I wanted to bring up that came out while we were on break, but we're going to go back into the courtroom live and then discuss more interesting points as they unfold. Alrighty, so it's still quiet in the courtroom, so we're going to have some in-studio analysis right now about what's going on in this case. Francey Hakes, thank you for staying with me because you're staying past your shift, which I really appreciate, because when we have these moments of silence, we want to talk about it. So this new witness, Detective Stephen Toyota, a prosecution witness, is about to discuss how he helped with the investigation and how he did have contact with Elder. Why is this going to be significant testimony to hear, and why does the jury need to hear this? Because, you know, it's always more fun to listen to the emotional pleas and the more human testimony. And right now, during today's shift, while we're here, it seems to be more procedural. So what do you expect to hear from this detective?
What it sounds like to me, Carissa, is that they're about to go over the Miranda waiver. They're going to show the jury that the defendant was fully apprised of his constitutional rights. It's something the jury has to consider when deciding whether or not a statement of a defendant was voluntary. The judge will charge them on that at the end of the case, that in order to consider a defendant's statement, they must decide that it was voluntary and that his rights were given to him. And so they're going to go over that. And then I think what we're going to hear, it sounds like, is Demetrius Elder's statement itself, which should be fascinating.
Right, and the statement itself will probably capture whether or not it was voluntary or not, which is what they were going to be playing in the courtroom before there was silence, although I see some lips moving. So let's go back into the courtroom and see what this witness is actually saying now. Now they are on a sidebar, so we can go back and discuss this and see. Maybe they're, Francey, why do you think that they're on a sidebar? Are they having issues admitting the recorded statement? Is the other side objecting? Why would they have a sidebar over just playing a recorded statement?
Carissa, that often happens. There's something about the recorded statement or something about the Miranda waiver that the defense objects to. They want one more time to try to prevent the jury from hearing the defendant's own words, because the defendant may or may not testify in the trial. So this could be the only time that if the jury hears from the defendant himself on a recording in his own words, and the defense might want to prevent it.
Right, they may want to prevent it, and they also may just want to be preserving the record for any appeal. So as long as they object and have a sidebar, they're preserving the record for a later appeal, which is good lawyering. We need to go to a quick break, and we'll continue to monitor the courtroom live with our feed, and we'll be right back.